Welcome to Sheppard's webinar. Please note that this webinar is being recorded, and a link to the recording, along with the slides, will be circulated after the program. If you have questions during the presentation, please use the Q&A button at the bottom of your screen to submit a question.
All right, I think we will get started. Thanks everybody for joining us today. We're really glad to have you here for what I think is going to be a very practical, hopefully practical conversation relating to med spas and important regulatory considerations in the space. I think we can go to the next slide, which has hopefully our faces. But just to start out, I figure we could do some brief introductions. I'm Jordan Greshkin. I'm a partner here in our Century City, California office. My practice focuses on healthcare transactions and regulatory counsel across a wide range of stakeholders, hospitals, medical groups, pharmacies, with a particular emphasis on evolving regulatory frameworks and emerging business models. I will let my colleagues Rick and Katie introduce themselves as well.
All right, I'm Rick Reifenbach. I'm also based in the Century City office of Sheppard, and I'm a healthcare regulatory attorney. So I work on all different types of regulatory issues, corporate practice of medicine, fraud and abuse, fee splitting, things of that nature. I work a lot with medical practices and serve as outside general counsel to a couple of medical practices, and enjoy working with med spas, fertility clinics, concierge practices. And thank you for attending today.
I would echo that. Thank you all for being here. I'm Katie O'Neill. I am an associate in our Chicago office. My practice is about half strategic transactions for all types of healthcare organizations, with a particular focus in PE-backed platform entities and strategic transactions for nonprofit entities. The other half of my practice, I serve as an outside general counsel and really enjoy commercial contracting. I have a particular interest in med spas as well as fertility and oncology, and I'm excited to dive in today.
Great. I think we can go to our next slide. So just, overview, what are we covering today? This is obviously part 2 of our webinar series on med spas. Last time we were focused slightly more on the transactional side, and our colleagues, gave a great overview on sort of the, different deal, considerations when we're talking about med spas. This webinar is focused on key healthcare compliance considerations and rules most relevant to med spas, with particular attention to things like staffing, supervision, licensure, fraud and abuse considerations. And I think one of our, core messages that we want you to, take away here is that, compliance is not just something that you address, starting out at launch and then you just put on the shelf. It really needs to be gotten right at the outset and revisited regularly, both to support the business success and to also help, mitigate, the risk of patient claims, regulatory scrutiny. Some of the areas that we, see come up, mostly or frequently in the med spa context: scope of practice issues, oversight of non-physician employees, whether, appropriate policies and procedures are actually, being followed, and, also design and administration of, patient membership programs, discounts, sort of, fraud and abuse considerations. So we're going to be touching on all of these and probably a little bit more throughout the presentation. So with that, I think we're going to turn to our next slide, which, we're going to be focused on licensing. So what does it mean, or, does a med spa need to have its own licenses? So we can go to the next slide. So, just jumping in, when we're talking about licensing for med spas, in itself, we're really talking about a layered set of requirements that, operators need to think about before they open their doors. And investors really need to conduct, diligence on, when evaluating a business target. This is not a one-size-fits-all, fits-all analysis. The requirements vary, as you might imagine, by state, by the types of services offers, by the types of equipment that are in use. But I would say there are a couple of key buckets that we're focused on. First level, you'll see on the slide, state level facility or clinic licensing. So there are several states that actually require med spas to obtain some type of facility or clinic license. Requirements can be quite detailed. Florida is a very good example of this. Operators need to navigate the requirements of the ACA regime, which has specific rules governing what constitutes a licensed facilities, what types of services can be provided. The takeaway really is that you can't just assume that this business is just a general commercial enterprise or a standard physician offices. The services being offered often trigger healthcare specific facility licensing obligations. The second bucket would be more of the device specific registration and licensure. So for example, if your med spa is offering laser treatments, there are often separate registration or licensure requirements that apply specifically to the use of one of those devices. A lot of times these come from state departments of health, state radiation control programs, or similar regulatory bodies. They're frequently overlooked, during the initial setup phase. So that's something we wanted to especially call out. Third, there are oftentimes local permitting and health and safety, requirements that go into setting up a med spa. Depending on where the location is, there may be zoning requirements, local business permits, fire and safety inspections, for example, public health requirements that need to be, satisfied. So a lot of times those might not even just be state requirements. They might be local, municipalities, and sometimes can be, actually more time consuming to obtain than, state level approvals. Next slide. Finally, well, not really, technically, a lot of people don't think of this as sort of like a licensure, thing. Naming rules and naming registrations often come into play, especially in the med spa, space. This is particularly relevant in the state of California, and New York for that matter. The naming process, that's usually administered by state medical boards and similar bodies. For example, under California law, a physician or medical corporation that practices medicine in a name other than a name including a licensed physician, they must obtain a fictitious name permit from the medical board operating that name. And here's why this matters. Obviously you have a lot of different med spas that operate under a trade name, Glow Aesthetics or Clarity Med Spa, whatever it may be, rather than a physician's name. That trade name triggers this fictitious name permit requirement in certain geographies. So very important, to keep that in mind. Look, and there are real, world regulatory consequences to not, getting this established. Operating without one of these, it can be, a violation of the Medical Practices Act. It can result in disciplinary action against a physician's license. So not just like an administrative, fine. Honestly, the absence of fictitious name permit, it's a diligence red flag that often needs to be surfaced and remediated before consummating a transaction. So bottom line on licensing here, we'd recommend doing your homework early, engaging local counsel, who knows the specific state and local requirements for where you're operating, and build the compliance review, including fictitious name permit questions. If you're in California or a similarly regulated state, it should be an important part of your diligence process.
Hey Jordan,
So,
I want to
Rick, if you have a
yeah, I just want to add on also, be sure to check at the county level too, for fictitious name permit requirements, to the extent you're operating under a trade name.
I think that's great. Again, people often forget about that. It's like, in California, you have your FNP, from the medical board. A lot of, folks don't always think about, well, LA County has their own, fictitious, business name regime that needs to be taken into account. And so I think that's a great point, Rick.
Yeah. I think
so that's,
all this,
oh, go ahead.
Yeah, I was just gonna say, I think all this licensing stuff kind of goes both ways too, right? Like so much of it really depends on the scope of what you're actually doing. Like if you're just
Yeah.
doing, cosmetic procedures and you don't really have a ton of overlap into dermatology or plastics, like this could be a good thing, right? Some of this could not apply. You could be off the hook. So I think it's just you'd rather be caught with it than without it. And I think doing the homework up front means, you might avoid sort of running it down rabbit holes that you don't actually need to comply with either.
Yeah. And I think that's a great point. And like I've seen this. I know certainly Rick has, and you have, Katie, I'm sure, in your practice. Like this is an area where, regulators sometimes use it's literally like a pretext to investigate larger issues. So like if this issue had been, sort of nipped in the bud, at the outset, sometimes you can avoid, a larger regulatory issue.
Yeah, absolutely. I think it just demonstrates, right? Like this is a professional operation and we have, everything we need to off the bat.
Yeah. So I think with that, I want to turn to sort of our next topic, which I'll also kick off. We can advance the slides. Enforcement trends, and we can advance it one further. Perfect. So I want to talk to you about, some enforcement trends that we're seeing in this space, because I think it'll give you, a snapshot of, what regulators are actually focused on and why getting the fundamentals right, why we're having this webinar is not just, a theoretical exercise. So, we're seeing a meaningful increase in regulatory, oversight and enforcement activities in MedSpas nationally. You have attorneys general, you have medical boards, nursing boards across the country. They're paying a lot closer attention to this sector. And the enforcement environment has become, I would say, materially more active over the past couple of years. So a couple of common threads that I just want to, touch on of what we're seeing: corporate practice of medicine violations, scope of practice concerns, problematic financial arrangements, just to name a few. Just, talking about corporate practice of medicine, or CPOM, most states obviously prohibit, non-physician entities from employing physicians, and exercising control over, the clinical practice of medicine. The rationale being that, clinical decision-making should be driven by medical judgment and not business interests. In the MedSpa context, that means that non-physician investors cannot simply own the practice outright or, put a physician on payroll in a lot of jurisdictions. The physician or professional medical corporation must own and control the clinical, operation. And, non-physician investors, they can certainly participate. And we'll talk about, management services organizations and some of the models to, structure this. But, those arrangements must be carefully designed to avoid crossing into, what folks would consider impermissible clinical control. Regulators are actively, drawing that line. California is a really useful, I think, example of where enforcement is headed nationally. News was made in recent months. The California Attorney General, recently settled actions against Carbon Health and Aspen Dental, and each of which involved findings that corporate management structures had crossed, that line. Look, both settlements, to use this as an example, they've required significant structural reform. These are also not isolated cases. They reflect a broader, trend of AGs and state licensing boards, scrutinizing these types of healthcare platforms, especially in the aesthetic medicine space. And so it's something to keep in mind. We do think that the med spa industry could be squarely in the crosshairs on this. So that's, just corporate practice. Next slide, please. Yeah, so talking a little bit more on the financial side of things, fee splitting and compensation arrangements are, they're often closely related to, corporate practice of medicine, types of risks. California's settlement, again, with Aspen Dental is a notable lesson for operators, including in the med spa space. MSO compensation models, can be scrutinized. We've seen state regulators really scrutinize percentage of revenue management fees and incentive structures that tie, physician compensation to volume. That can implicate both, CCOM statutes, fee splitting statutes, anti-kickback concerns. So, at a bottom line, any MSO arrangement, it needs to be grounded in fair market value. It needs to be structured to reflect a genuine, separation between administrative support and clinical control. So it's another, area that, folks should really, pay attention to in this space. Next slide. Just a point on, what typically triggers regulator attention. This is not an exhaustive list, but a lot of times what can kind of trigger these are, adverse patient events, consumer complaints, aggressive advertising, claims, employment disputes, increasingly issues involving GLP-1s and peptides. As demand for weight loss injectables has, surged, many med spas have rushed to offer these services without the appropriate prescribing relationships, supervision structures and protocols. I did want to call this, these particular issues out because, again, using, California as a notable example, its Board of Registered Nursing has published guidance and launched an active enforcement initiative around drug compounding by RNs and APRNs in the med spa context. So, California law is explicit, no RNs, can technically compound drugs, meaning, RNs, they can prepare medications exactly as labeled, but they can't alter concentrations, change dilutants, things like that. This is really relevant even beyond California because, many states in nursing boards are taking a similar, position. So, if you're med spa, if you're investing in a med spa that's, offering these types of services, IV drip services, vitamin injections, things like that, this compounding question, and I know, Rick, your mute is off, so I know you want to chime in. It really needs to be built, into these protocols.
Yeah. I mean, I agree with everything you said. I just want to sprinkle in also, sometimes the complaint comes from a competitor who, reports you to the medical board. And we've seen that come up before. So that's another one to keep in mind.
Yeah. So, definitely a hot button issue. Obviously, look, there are, a number of, important things on the regulatory side that we're going to dig into, but just wanted to highlight a couple of these items that we're seeing on the enforcement end. So I think with that, I'm gonna turn it off to a different topic.
Yeah.
You can advance the slide. Yep.
All right, and let's go to the next one, please. Okay, I'm up. Okay, so the role of the medical director, as Jordan discussed, med spas are medical practices. And so while they might have non-physician investors in the management company or other parts of the business, I mean, ultimately the medical aspects of the business have to be supervised by a physician, whether it's the doctor that owns the practice or a designated medical director who oversees the day-to-day clinical obligations and responsibilities. The core responsibilities of a medical director, we list them here on the slide, but they typically include reviewing and approving the clinical policies and procedures, making decisions related to the hiring and firing of the clinicians. Most med spas rely on mid-level practitioners such as PAs and NPs and RNs for the day-to-day work, and Katie's going to talk a bit about that in the subsequent slides. But the physician has to supervise those people, and on a state-by-state basis, there are ratios in terms of the number of mid-levels that the medical director can supervise. And then obviously the medical director provides physician-level input on clinical care. In particular, if there are any complications, the medical director will get involved. And then to the extent that there is a management company, and Jordan alluded to the management company PC model, that medical director often is the clinical liaison with the management company to review clinical policies and kind of translate the clinical aspects of the practice for the management company. And this is a very important role. The medical director is there to provide the ultimate clinical input, which obviously is very important from a healthcare standpoint. But also, to the extent there's a problem or to the extent there's a medical board inquiry, they come to the medical director or the owner of the practice. So the buck really stops with the medical director. And, it's important for the medical director to realize that and everyone sort of affiliated with the medical spa to realize the importance of the role. All right, so what makes a good medical director? We list some more bullet points here on the slide. But I'd say, first of all, that medical director has to have the right kind of experience for a med spa. It's not sufficient that that person is just a physician, but that person needs to have the right type of clinical experience. And I've seen that go wrong. I've seen other practices where it may be a PA that wants to start up a med spa, and the PA has the right kind of experience, but that PA needs a doctor to own the practice, to be the medical director, and finds a doctor that, has a specialty that's completely unrelated to the med spa services. And, the example I have in mind, there was a patient injury. It got reported to the medical board. The medical board came in and took a look at this arrangement, which had this, again, the buck stops with the medical director. That medical director, didn't have the right kind of experience. And that was the wrong, foot to start off this response to the medical board investigation with, we have a doctor that doesn't have the right kind of skills to even supervise. So anyway, that was a lesson learned that I've seen in the way that this can go wrong in practice. Also, I think in terms of who makes a good medical director, it's someone, there has to be a certain level of engagement. That person should want to be there, should be, boots on the ground, supervising the clinical operations, should know all the staff, should know the location, should be familiar with the equipment, should take a lot of pride in the position. Conversely, what you don't want is someone who's just, willing to draw a paycheck, but doesn't really understand the role. And look, we see that as well, and I think that's a red flag. But I think it's important for the medical directors to want to be there, understand the role, also read the medical director agreement. Understand like that make sure there's not a mismatch between their expectation with what they think the role is with how it's documented in paper. And we've seen that go sideways as well when doctors sometimes sign things without even reading them. And then let's see, what I also want to say, in terms of that medical director agreement, we're going to touch on more fraud and abuse issues a bit later, but, I would expect it to be, you want it to check all the compliance boxes as well. So, in writing, have a clear list of the services provided, compensation that is fair market value and reasonable for that, for the industry. And then, no compensation based on any business generated by the medical doctor. So no referral fees built in there. So anyway, that's how you start off on the right foot, I think, with your medical director and what to look for in these types of arrangements. Katie or Jordan, anything to add there? No. Okay.
I think your point about, the medical director agreement, I know we shared a war story earlier this year about, seeing what a physician has signed, and then them not understanding that their understanding of the relationship was fundamentally different than what's documented on paper. I think a lot of times, especially in typical PC MSO setups, you have form documents, and I think people, even though they're experienced and in practice, with these types of arrangements, they think it's very plug and play. And I think one of the lessons, certainly from that example and what we're talking about here is, nothing should be necessarily plug and play. Everything should be, really tailored to the operations that are actually, going on and unique to, the physician's expertise and the mid-level practitioner's expertise. So, yeah.
All right, next slide, please.
Okay. I have actually seen someone, by the way, be excluded from Medicare for a problematic medical director arrangement. Not in the med spa space, but it's real. And so it is really something to be mindful of. Regardless of, who the medical director is, we also want to think about the physicians who are providing and overseeing services within the practice. So this is true whether or not the state that you're in overseeing services within the practice. Your has a CPON. Okay. Sorry, everybody. I'm in the office and we lost internet for a second there. But yeah, so while our medical director has full responsibility, we still need the actual providers in the office to be overseeing the actual delivery of care. And I think one of the most important delivery of care. And I think one training, so making sure that the policies and procedures are clear, like in the same way that Jordan was talking about the medical director agreement not being plug and play, the same needs to be true with respect to matching policies and procedures and oversight to actual operations. That includes things like patient consents, actual treatment protocols, and then charting and documentation for services, right? When I was a nurse, there was that old maxim of if it wasn't charted, then it wasn't done. And I think, if there ever is an investigation or if you ever have an issue that's reported to your professional liability carrier, you want to be able to defend yourself and provide a documented record of compliance and proper operations. Some of the areas of highest risk that we see relate to penetration of tissues. So that includes things like high energy devices, Fraxel lasers, for example, injectable drugs, right? There's always the risk of an allergic reaction, particularly with fillers. You want to be careful of that. Jordan highlighted before, but any kind of IV therapy, we should only be putting drugs together based on the manufacturer instructions. There really should not be any compounding going on in these med spas. Any kind of deep chemical peels that are go off video for a moment here. All right. And then as Jordan has already alluded to, you always have the risk for an investigation. And that includes not just the med spa, but of course also the individual providers too. And to Rick's point, while the risk is highest for the medical director, who, is ultimately responsible for the quality of care at the facility, it can also extend to the other individual providers as well. Next slide. Okay. All right. So who is working in the med spa, right? I mean, to the point that was made earlier, leverage is really critical. And so we oftentimes see, people working at the top of their license, which makes business sense and clinical sense as long as it is, structured appropriately. I'm just going to touch briefly on the different types of providers who you may see, and really what they should and should not be doing. With respect to nurse practitioners, the scope of practice varies by state. There are certain states, in fact, most allow them to practice independently. So that includes things like full patient evaluations. They can make diagnoses, order and understand diagnostic testing, and also manage treatment. There are some states like California in which you need to have standardized procedures for nurse practitioners. So there's a real element of physician oversight there. Some of the high areas of risk for them, not every nurse practitioner has the authority to order drugs and devices. Prior exams, again, sometimes that really requires physician consultation. And as we alluded to earlier, there may be supervisory ratios involved. So in California, you can have one physician supervise up to 4 nurse practitioners at a time. Physician assistants are a little different. Their scope is going to be more narrow. So they really are only supposed to be practicing within the same scope as their supervising or collaborating physician. The rules are loosening across the country. We've seen this in California and some other states, but with physician shortages and the pivot to mid-level providers, there's more of an interest in expanding scope. So collaboration is more flexible. You may see a contract with these folks that doesn't require, regular chart reviews by the doctor or regular check-ins. But there are other states that maintain tighter requirements. And they also may have a limited ratio. In California, there's a maximum of 8 physician assistants who can be supervised at any given time. Registered nurses, this is a personal favorite for me as a registered nurse. We should not be diagnosing people, writing orders, right? When you think about registered nurses, you need to think about somebody who is really performing subject to supervision at all times. We've already mentioned the risk about compounding drugs. Medical assistants, you may see some clinical duties for these folks, and they often have a blended clinical administrative role. Again, we should not see clinical, serious clinical tasks being performed by this type of employee. And then finally, estheticians. I actually think this is one of the areas of highest risk. So estheticians can do facials, they can do LED type treatments, cosmetic skin assessments, things like that. But we're really talking about the top level of skin only. Anytime you're getting into things like microneedling, dermaplaning, lasers, that is not something that's really safe for them to be doing or within their scope. And Rick, Jordan, I'm interested to hear if you have any, particular experience with trouble areas across these different types of providers.
Yeah, I mean, you just mentioned one. Funny enough, Rick and I, dealt with an issue earlier this year that actually involved sort of an esthetician practice that, one of the, essentially got raised to the medical board, and we're representing a physician and his practice. And, essentially, there were accusations that there wasn't proper supervision, and, essentially that this esthetician practice, which was organized as an esthetician practice, was, doing things like, employing nurses who were doing microneedling. And so there wasn't, and our, client wasn't even aware, essentially, that microneedling, which is more of a nursing procedure, was being done. And so I think it's really important, like this box here, this chart, I think really is an important highlight of the different components that go into different service lines when you're operating something in the aesthetic medicine or, med spa space. And people need to, pay very close attention to which personnel are authorized to do the types of services, and the actual bona fide supervision requirements that go with it. So really important.
Yeah, and I just wanted to echo a couple different points. The first was that I think the scope of practice for these types of professionals in each state is constantly being revisited and potentially expanded. Like Katie said, I mean, with our primary care physician shortage in a lot of states, they're expanding what nurse practitioners can do, PAs can do. And so that's one thing to keep an eye on, that even, what they can do now might not, they might have a broader scope of practice in 5 or 10 years. And then also in terms of risk areas, we get a lot of questions about medical assistants and what they can and cannot do. And I think, especially in California, that's an area of some regulatory risk. I think there's a temptation to potentially overuse medical assistants beyond the scope of their practice. And the California Medical Board has some very good FAQs about medical assistants, because the medical board is very focused on this issue in terms of what they can and cannot do. So that's another one to keep an eye on.
Yeah, I think it's easy to have scope creep as well, right, across these different provider types. And I try not to be fear-mongery when it comes to the work that we do, right? Like, I understand people need to operate a business, but I will say, particularly on the cosmetic side, you're talking about people and their faces, right? I mean, if something goes wrong, the odds of somebody making a complaint, being upset, right? It's sort of a higher risk area. Next slide, please. Okay, so we've talked about this a little bit, and I just want to just push on a couple of these things. So when we're talking about what does supervision require, I mean, I would say, first of all, it really depends on the scope of services and what the med spa is delivering. There are some instances in which you don't necessarily need to have a physician to mid-level provider arrangement every single time. In California, we actually have a statutory framework that allows for greater flexibility within a healthcare organization. So you can sort of designate by policy who is responsible at any given time, which is good, right? In the case of an emergency, everyone should know where to go and what to do. Any kind of delegation, in addition to the licensure issues, even if something is within someone's scope of licensure, you have to make sure that that person is competent, that they've been trained, right? That they know where the risk areas are with a particular laser, that they know where the complications are likely to arise, and that they know what to do in the event that that happens. It does not necessarily need to be that the physician is on site all the time, right? Sometimes electronic communications are fine. The caveats to that, of course, are, you know, if you have sometimes PAs will perform surgical procedures. And so where you have something, say you're doing a procedure for the first time, you have somebody who's receiving services under conscious sedation, those are areas of higher risk and higher attention where the physician really should be on site and immediately available. As I mentioned, there are some instances in which physicians need to review or co-sign charts. And Jordan, I think you made this point earlier, but this is the type of thing that you want to have, right? Like if an investigator comes and says, like, show me that you have the correct supervision arrangement, show me that you've been documenting and going over the chart, like you really want to show that your operations match with what your policies or procedures and medical director agreements say.
100%.
Yeah. And I think that kind of speaks to why this is really an evolving obligation as opposed to something that's static. It'd be great if you could set it and forget it, but I just, you know, I think the reality of it, that is, of course, the law changes, scope of practice changes, the business changes, and you have to be responsive to that. So let's move to policies and procedures, actually, Jordan. Maybe we'll move to the next slide and you can walk us through.
I think that's a nice a nice segue. So obviously we've been talking a lot about, you know, legal and structural frameworks, licensing, supervision, enforcement. Want to talk about, you know, a little bit about the sort of the operational translation of all of that. Like, what does actual good compliance look like on the ground in terms of, you know, policies and procedures and training? So I want to sort of focus on two pillars here. You know, the first, which you know, I think Katie did a great job alluding to, is, you know, procedure-specific documentation. So, you know, med spas minimally should maintain, you know, paperwork as a best practice for, you know, each of the types of procedures they offer. So, you know, that includes, you know, neuromodulators like Botox, dermal fillers, microneedling, dermaplaning, vitamin injections, peels, things like that. You know, the reason why this matters from a regulatory and liability standpoint, I think, is twofold. You know, number one, you know, having properly documented protocols demonstrates that your medical director and the clinical personnel, you know, has an established clinical framework. This is a supervised medical clinical environment. It's not just a spa where, you know, procedures happen ad hoc. You know, secondly, you know, if something goes wrong, you know, an adverse event or a patient complaint or a regulatory inquiry, your written protocols, your written policies, that's your first line of defense. You know, they demonstrate, you know, from an evidence standpoint that the staff had clear guidance. The guidance was hopefully clinically appropriate, you know, and that the operator and the folks involved in this took and take compliance seriously. So definitely, you know, paper, you know, having, you know, written documentation is really important. Next slide. But, you know, paper, it's necessary, it's not sufficient. You know, the second pillar, you know, of sort of policies and procedures and training is certainly regular training. Staff training, again, should minimally cover drug administration, inventory management, patient exams, infection control, medical record documentation. I can go on and on. This is not an exhaustive list, but those are, the big things that need to be, within, training, regular training protocols. And, I said at the outset, regular training. Sort of the theme that, we started out with, this is not a one-time onboarding exercise, set it and forget about it. Medical staffs, there's regular turnover. Regulations change all the time. You may want to update, the types of services and procedures, to your service offering. Your training program for a med spa, it needs to be ongoing. It needs to be documented. It needs to be tied to the protocols. Frankly, emergency protocols in particularly are, an area that I think med spas, I think we would all agree that, med spas often underinvested. Staff need to know what to do if a patient has an adverse reaction, and they need to have practiced it. So, I think taken together, procedure-specific protocols, regularly documented training, to me, that's part of the foundation of a defensible compliance program. It's hopefully going to be enough that, God forbid you have a regulatory inquiry, that this is the evidence that's going to, set it right. These are the types of things that, regulators, plaintiffs, attorneys, first look to when something goes wrong. So that's what I got. I think I'll turn it on.
All right, I think we can go to the next slide.
Yeah.
Oh, yes. All right. So I think we have appropriately really put a big focus on the clinical compliance and operations component of a med spa business. Obviously, that's, the most important piece, but we also want to talk about the business. And one of the things that's nice about med spas compared to some traditional healthcare businesses is that there oftentimes is more flexibility in terms of structuring the business offerings. And obviously there's a much larger cash pay component as compared to a traditional, payer-based revenue stream. So one of the things that we get asked about all the time in the med spa space is what kind of patient incentives can we use? I think the word patient incentives probably makes Rick nervous, regardless of the context. But I do want to talk about it because I think it's fascinating. And I think this is an area where you really need to make sure that you talk to an attorney. Obviously, there's a healthcare regulatory component, but what's really at issue here are consumer protections. So to the extent that you have actual customers or you have potential customers, the way in which you are engaging with those folks really matters. There are, Telephone Consumer Protection Act requirements. There are website and cookie issues. You also have, automatic renewal laws, and those are, across different states. And one of the bigger issues here is even if these people are not your patients, if you are using your website to obtain, identifying information about them, you really are opening the door to a potential class action lawsuit. And I have seen that not only pose risk, right, from a legal standpoint, but I've also seen it pose a lot of risk in the transaction context. This is something that really savvy buyers are looking out for and accounting for from a diligence standpoint. So if you are going to, have a website component with cookies, it's really important to run that past a data privacy person and a HIPAA person. In California, you also obviously have the CCPA and have some specific privacy rules in other states. And for those folks who are your patients, you can have a membership or a reward program. Sometimes obviously you have those from vendors, right? You can have the drug manufacturers offer points for recurring services like Botox or fillers or other kinds of treatment methodologies. But if you're going to do your own membership type program, you really want to be sure that it's clear, that all the terms and conditions are understandable, by a lay reader. They need to really have it has to be easy to get in and get out. So if you're going to allow somebody to sign up for your points program online, they need to be able to cancel online. Needs to be clear what happens when they cancel, right? Are they allowed to keep all of their points? If they stop using it, do you auto cancel it at some point? Do they ever expire? And if you, the business, want to change the way that the points program is administered, then you need to also include some disclaimers about how you may do that, what types of changes may occur, what kind of notice you're going to provide, things like that. And of course, from the insurance standpoint, you want to make sure that there's not duplication of payment there for the same services. If you want to do some kind of Botox party, filler party, anything like that, one of the most important things, obviously, is ensuring that the standard of care is met at that event the exact same way that it would be in the office. So that includes universal precautions, it includes reasonable infection control measures, and then, standard patient consent, privacy, evaluation, again, all the typical standard of care services that you would provide. And Rick, I know I was kidding earlier, but I know you and I have really looked at these patient incentive issues in detail. I'm curious if there's anything you would add.
I would just say, just generally on this topic, I think the consumer protection state laws are very important to the point of almost being a trap for the unwary in this space. I would say also, you need to be careful that nothing about the structure of this type of program looks like an insurance product itself. That could implicate state insurance laws. So that's why I think, Katie does a nice job of flagging a lot of the issues here. And these things need to undergo like fairly careful legal review to make sure that they're compliant.
Yeah. And do you want to speak a little bit more? I think we're going to move into marketing and advertising more generally as well, where I think there could also be more traps for the unwary, as you suggest.
Yep.
So next slide.
Yeah, let's keep going. We've got about 12 minutes here. Next slide, please. Okay, so med spas, are an area with a lot of advertising, and I think we all see it. So there's, websites and social media, print ads. I've got kids, and they're always very excited when they run into influencers at the Century City Mall, and influencers have a big role in the med spa space as well. So there's just a lot of advertising in general. But it's important to remember that since med spas involve medical services, they're not like other businesses. There are more rules that attach to the way that they can advertise. They're subject to physician practice acts. They're subject to medical board supervision. And so it's a lot more limited in terms of what they can say. And I think, the recent Attorney General actions that Jordan covered, sales and marketing, advertising, those were components of both of those cases. So I think, the AG is very focused on these types of issues as well, in addition to the medical board. And so I came up with a list of sort of like risk areas, like what to do or not do when it comes to advertising. And so here's the list. You need to avoid misstatements of facts or key omissions that could mislead a reasonable consumer. They have to be accurate. Statements or imagery that's likely to create unrealistic expectations in the med spa space that can create legal risk. The use of models or other individuals who are not actual patients, but are presented as a before and after, that's a high risk area too. Typically need disclosures, this person is a model or this person is an actual patient, but he or she had this type of procedure. So there needs to be a level of transparency in the advertising that will avoid an accusation of misleading the customers and the patients. And then any claims in the ads, that are not supportable by fact or scientific literature, just need to be very careful in terms of what is going into the ads. And I think, I've worked with clients that want to be aggressive. They want to, they're a startup, they want to get patients in the door, and so they're willing to be more aggressive with what they're willing to say. And I will tell you, because we see it from that perspective, but then also we do a lot of deals in this space. And when we're acquiring a med spa and we see aggressive advertising, that gets noted in the due diligence process. So it is a risk area that you kind of need to balance your risk tolerance and think, well, at some point I do want to sell this business. How would buyer's counsel react to this? So it's just another consideration. And lastly, I wanted to mention on the topic of influencers, and that's probably its own separate presentation. But what are some of the areas we focus on when it comes to relationships with influencers? It's things like, what is the influencer saying? Is what he or she is saying accurate? Because there's a risk it will be attributed to the med spa. And so oftentimes there may be approval rights. What is the content that is being put out there by the influencer? And should the med spa have say into that? Indemnification issues related to these different liabilities, and then disclosure issues. Is the influencer disclosing that they have a relationship with this med spa? So anyway, that's kind of a fun area of consideration and a real hot topic right now too. So Katie, did you have something you want to add?
Well, I was just going to say one question that I had for you. I mean, I know you were talking a little bit about the Carbon Health and Aspen Dental settlements, but
Yeah.
one of the things that comes to mind for me as well is the sort of during visit marketing, right? Like it's not only sort of outside advertising, it's also like while someone is in the office, maybe having some upselling there. And I'm just curious if there was any insight that you had in terms of like the PC talking about that as opposed to, a management company or somebody else sort of directing the in-visit sales that might be going on at a med spa.
You're right. I mean, that was, I think, an issue in one of those AG settlements. The AG didn't like the selling or providing, like basically a commission to selling those products. So I think it's a risk area. I think that there's a concept of white coat marketing that regulators don't like, meaning everyone trusts their doctors or their nurse or their PAs. So then when they're recommending something to you, you let your guard down and you tend to want to believe them. So I think that's an area of risk that needs to be navigated. And also, there needs to be a fair amount of transparency in terms of any financial incentives associated with selling those types of products.
Right. In addition to kind of appropriately consenting the patient to the extent you're adding on something that, isn't necessarily what they came for.
Exactly.
Yeah,
So,
that makes sense.
okay. Anything else? Okay. Next slide, please. All right, next slide. Yeah, the last couple of slides here with our time left are fraud and abuse and other types of sort of a regulatory catch-all. And so we've touched on some of these issues already. But I did want to say, med spas are a cash pay business. And so that the bright side of that is that a lot of the laws we healthcare lawyers worry about, like the federal anti-kickback statute, the Stark law, they're not going to apply in this context because there's not federal healthcare program dollars at issue. But we can't let our guard down because there are, on a state by state basis, there's state laws that are counterparts to these federal anti-kickback statute laws. So many states have anti-kickback laws, have fee splitting laws. They may be freestanding, they may be in medical practice acts, physician practice acts. And so that has to be considered as when structuring these types, relationships in this space. There are a number of treatises that summarize state anti-kickback statute laws. So I think, if you're moving into a new state to start a med spa, you should consult, a treatise, get the lay of the land, because you might be in a state where these laws don't apply, in which case you may have much more flexibility. If you're in California, if you're in Illinois, if you're in New York, and in a bunch of other states, you do need to worry about these types of laws. For example, California has several of these types of laws. We've got Business and Professions Code Section 650, which is our main anti-kickback statute, and it applies to cash pay businesses like med spas. And so we get a lot of questions in this space about in California about compliance with Section 650. So what are the types of issues or arrangements that come up? A lot of times it's the management agreement. If there's a management company that's managing the med spa practice, which, as you've heard, is a very common structure, we look at the management fee. Is that going to comply with our state anti-kickback statute? We look at, is there a separate marketing fee? That's a higher risk set of services or marketing services. We have some exceptions to our state anti-kickback statute law that we try to structure things into here. And like Katie teed up for me in the last slide, sales and marketing staff. This comes up all the time, not just in the med spa context, but in a lot of medical group contexts. Can you pay commissions? How can you compensate your sales staff? Things of that nature. And a lot of it is fact specific. What are they doing? Are they employees? Are they W-2 or are they 1099s? But those are all very common, fraud and abuse type issues we look into. And relationships with pharmacies and other types of healthcare providers. These come up, a lot of times there's employee leasing arrangements, there's subleases of space, there's other types of services arrangements. And, many times these are completely legitimate. And we look at, what are the services? How are they valued? Is there a legitimate business purpose for those arrangements? In which case they may all be appropriate, but, you need to have your guard up to the extent that there's any cross referrals going back and forth between these types of companies and really ask and kind of push, like, what is the purpose of this arrangement? So, any other comments on that slide? Okay. And let's take it to the last slide here. Okay. And Jordan touched on, the recent AG opinions and corporate practice and medicine concerns. But I think it's worth, just worth kind of finishing on this point. And also, it's not just a California issue. This is something that you need to worry about in many states, if not most states. The CPOM structure, the PCMSO structure. Jordan, you want to weigh in?
Oh, no, I would just say, in each state, has their own, sort of standard, for CPOM. And so, obviously, you have a state like California that has, sort of strict requirements. And to a certain extent, you could say, well, if I'm following, the California, law or model, that should port, over to, most other states. And I think that's generally true. But at the same time, there are nuances in, probably each particular state that are important. And I think recognizing those nuances, documenting those nuances, I think it's low-hanging fruit that could be meaningful. Again, in an unfortunate event of a regulatory inquiry. So I think those differences actually are important to note.
Yeah, and one thing we discussed, and Jordan covered, medical group policies is, given these AG investigations, more scrutiny on what is the management company doing, what is the medical practice doing, practices may want to consider having a policy that like clearly, defines those roles. And if investigated, you hand the regulators your management agreement, but you also say, we even have a policy and training on these issues, here you go. So let me just make a couple other points here and I'll wrap up. A lot of times, there are these affiliated companies of a med spa and there may be referrals back and forth. Some states require disclosure of those relationships. California is one of those states. So patients need to understand, oh, I'm being referred to this surgery center for this, procedure. To the extent that the doctors who own the med spa also own the surgery center, there should be a disclosure there to the patient. And I think that's a best practice, even if it's not required by, state law. So something to consider. And then the last point I want to make is this corporate formalities. And by that, I mean a couple of different things. So if there are, relationships with other companies, a management company, an affiliated surgery center, each entity needs to be, set up as a freestanding entity and it needs to kind of stand on its own. It needs to have its own bank accounts, its own name, and everyone needs to stay in their lane. And the reason why this matters is because, the medical board will come in and here's a war story is that medical board comes in and investigates a friendly PC structure, right? And asks the PC, the medical group for, give us all your organizational documents. Well, the people who worked for the med spa and the management company, a lot of times don't understand the structure that they're operating under. And they actually produced all the documents for the management company to the medical board, thinking that that was the medical practice. Well, that's not how you want to start your response to a medical board inquiry. So again, having separate names, bank accounts, business licenses, all the appropriate licenses for each entity, like Jordan discussed at the beginning of the presentation. And then lastly, conducting regular board meetings. These medical practices are set up as, professional corporations, have a quarterly board meeting. It's probably required under the bylaws anyway, but, have a board meeting, document in minutes that meeting occurred. Again, it just proves to the outside world that it's a legitimate structure. So that's it from me.
Wonderful. Well, this was a great discussion. Thank you, guys. I feel like I always learn something new, even though we've been doing this for a long time. There's a lot to take away from today.
Yeah, so great speaking on this topic. Hopefully the attendees also learned something as well. But if you have questions, I know we didn't leave really any time for Q&A here, but our contact information is here, and we'd love to continue the discussion.
All right.
Thank you, everyone.
Thanks, guys.
Talk soon.